I'm recording this, so I'm on record. Welcome, everyone. As people start to populate the room, we'll get started in a bit. I am wearing my Eagles jersey today because we are doing this for Pennsylvania, New Jersey audiences. I've heard a lot that people have been saying it takes a village to get us through this coronavirus COVID-19 epidemic. But I just want to be clear that that village does not include aligning with. I'm not going to align with New York Giants. I'm not going to align with the Pittsburgh Steelers. So let me be clear that notwithstanding that we're all in this together, my allegiance is completely to the Philadelphia Eagles, and I want them to stay well and COVID-19 free, but I thoroughly hate the New York Giants and the Pittsburgh Steelers.
Well, had we coordinated a little better, I would have worn my Giants jersey.
Yeah, I figured as much.
Represented
yeah.
for the state of New Jersey and New York.
All right. Well, welcome everyone. Thank you for coming out. This is nice. I mean, we've been doing some of these Facebook chats where we get, a few hundred folks coming in, and I thought this would be a little bit more intimate. Welcome everyone. Let's see, hopefully I have it up somewhere so I can see comments coming in. We'll try to answer as many questions as we can. I'm going to introduce myself, and then I'm going to allow my co-presenter Amy Vazquez to introduce herself and her organization. My name is Eric Meyer. I am an attorney, a labor and employment attorney at Fisher Broyles, and we are a nationwide law firm, and we are the largest cloud-based law firm in the world. So this remote working thing is nothing new to me, although I do have 4 kids at home, whereas I didn't have the 4 kids at home before. So that's a bit. I'm also the publisher of a blog called The Employer Handbook, which is at theemployerhandbook.com. And welcome everyone. And Amy Vazquez from the New Jersey Employers Association of New Jersey, excuse me. Why don't you tell everyone a little bit about yourself and your organization?
Sure. So I am the Director of Legal Content for Employers Association of New Jersey. In case some of you aren't familiar, EANJ is a nonprofit membership organization. We're comprised of employers located throughout New Jersey. Currently, we have about 3,500 employer members, and our mission is to help good employers be better. And we do this in a number of ways. We do a lot of training and education, seminars, webinars, outreach. We'll do in-house training for our members, and through informed discussions with the membership. So our members have direct and unlimited access to our professional staff. We do have attorneys on staff. However, we do not provide legal advice, but rather we provide members with information so that they're able to make informed decisions when it comes to issues concerning their employees. We'll help explain to them various aspects of federal and New Jersey employment law, and point out where there might be risk in taking one course of action over another. We're not a substitute for an attorney. Again, we don't provide legal advice. It's really just about education and information. And typically the calls that we receive kind of cover all aspects of the employment relationship, from the time someone's hired until they leave, and everything that falls in between. So we take a lot of calls on things like wage and hour issues, leave administration, mandated benefits, which in New Jersey is a pretty big deal. We have a pretty robust system for temporary disability, family leave insurance, New Jersey's new earned sick leave law. But we also do things with like health insurance, COBRA, ACA questions, discrimination, harassment, just to kind of rattle off a few. I've been with EANJ for almost 21 years, and we are kind of a small organization, small but mighty. But like in any small business, we all tend to wear many hats. So primarily, I help members when they call with their questions. I teach courses on FLSA, New Jersey wage and hour issues, FMLA, but also I help to track the legislative and regulatory compliance mandates, the case law, the agency directives. We want to make sure that we're keeping our members as up to date as possible. Eric and I have never actually met before, but we've been connected on LinkedIn, I think, a long time, and I definitely rely on your blog and your posts to keep me in the loop so that I can do the same with our membership. So it's been a good relationship.
Thank you, Amy. And all of that talk about Amy and her organization not providing legal advice is a perfect natural segue to a disclaimer for today's Zoom chat. Neither Amy nor I are providing legal advice. You know, lawyer, we've got a bunch of lawyers attending here, but we're not your lawyers. We're just lawyers. And if you think we're giving legal advice, we're not. We're assuming that all of your questions are hypothetical. We're assuming that all of your questions are being asked for a friend. So we're not creating any attorney-client privilege here. And yeah, we're not giving legal advice. So if you're cool with that, hang out with us for about an hour or so. And if you're not, well, you know, you can still hang out, but we're still not creating any sort of attorney-client privilege or giving legal advice. So, Amy, I'm already seeing questions come in about New Jersey. Pennsylvania, probably not so many questions because it's pretty straight. It's pretty clear cut in Pennsylvania, but I'm going to let you do a lot of the heavy lifting on New Jersey. And do you want to tell the folks a little bit about, you know, what's been going on in New Jersey, whether it's executive orders? I see, you know, Governor Murphy's tweeting like every 15 seconds, 7 executive orders signed in the last 48 hours. You know, people have questions about, I don't know, the law against discrimination. I already see questions coming in about the overlap between temporary disability benefits and FFCRA. Why don't you give everyone an overview of what's going on?
Sure. So, you know, of course, you know, it goes without saying these past few weeks have been intense for employers. You know, at EANJ, we do track our inquiries from our members, our phone calls and our emails, our interactions. And on average, I would say that we typically get about 400, give or take, in a month. Last month we had about 20, over 1,200 in the month of March. So, you know, it really just, it's an enormous uptick, and it really gives you, you know, a sense of, you know, the current crisis and what's going on. Many of these calls have had to do with how to handle furloughs and layoffs. This is not surprising. New Jersey had 362 new claims for unemployment filed over the past 2 weeks. That's a pretty astonishing number, pretty overwhelming on the system.
Wait, you said 362 or 362,000?
362,000.
Okay.
Yeah.
I can handle 362. Yeah.
Yeah, no, the DOL is saying that it's a 1,600% increase in claims. Wow. And I had the opportunity to listen to the Commissioner of Labor earlier this week on another webinar. And, you know, he's using this stadium analogy where, you know, you have everybody showing up for the Giants game and they can't wait to get into that stadium. But everybody has to go through security and everyone has to, you know, go through ticketing. And, you know, eventually everyone will make their way in and will be paid their unemployment. But, you know, you sort of have to give room for some hiccups, right? Because somebody's not going to have their ticket at the gate, or, you know, somebody, whatever, they're trying to bring their water bottle in and water is prohibited, but you get the idea. So the system is just very overloaded, but they are working on it. And really, New Jersey DOL, in my opinion, has done a fantastic job of getting information out there to employers and to claimants as well. You know, we know that unemployment is ultimately between the claimant and the state, but employers, I find in many cases, and especially now, you know, they're looking to help guide their employees in the right direction. They want to give accurate and helpful information so that the employees can successfully, you know, file their claim and start collecting their benefits. But there's so much confusion. And I think a lot of that comes from the new CARES legislation that was signed into law back on March 27th. And among a bunch of other things, it greatly expands the reasons for why someone can collect unemployment. So people who were never eligible for unemployment in the past, like independent contractors and sole proprietors, they're now going to be eligible for benefits. People can now collect unemployment benefits for reasons that have never been covered in the past. So if someone was diagnosed with COVID, or they're experiencing symptoms and they're seeking a medical diagnosis, or a member of their household is diagnosed and they're providing care to that family member, these are now things that are covered for unemployment. Traditionally in New Jersey, when we think of these individuals, New Jersey has this robust system of kind of a safety net in place. We have temporary disability benefits. We have family leave insurance benefits. Employees can still file claims under those systems. It's just that now unemployment is sort of thrown into the mix, and an employee has more options of what they might take advantage of. And I think a lot of the calls that we receive, and I'm happy to take any questions on this too, is sort of the coordination of all of this. If someone is diagnosed with COVID, what happens first? How do we proceed through that? And how does it figure in with their existing New Jersey earned sick pay? And are we subject to the mandated emergency sick pay under the FFCRA? So a lot of my day is spent helping members walk through, just making sense of what these new mandates are. You may have seen, and this is I don't know if you could see it in the screen. This is a form that the New Jersey Department of Labor has come up with. It's their COVID-19 scenario and benefits available. It's up on their website. It's a fantastic resource. I highly recommend anyone take a look at this. And it kind of lays out 12 different scenarios and what the employee would be eligible for depending on what their situation is. So that's a great resource. The other big part of the CARES Act is this I guess we'll call it the $600 stimulus payment that's going to be paid for all claims between now and the end of July. So this $600 payment is going to be in addition to the claimant's normal unemployment benefit rate. So, we're finding that in some cases, a claimant might end up receiving more money on unemployment than they would have had they actually been at work. That's a tough pill for a lot of employers to swallow. And that $600 payment also, so New Jersey, if you're fully unemployed, you're able to collect unemployment, as long as you're unemployed for through no fault of your own and you meet the eligibility criteria. With the CARES Act, we have all of these new expanded reasons why someone can collect the benefit. But New Jersey also provides for a partial unemployment benefit. So if your employer reduces your hours, you can collect a partial benefit in New Jersey. And this $600 stimulus amount is going to be available to those collecting that partial benefit as well. We just got confirmation on that earlier this week. So that's kind of a big deal. That's kind of a big deal for employers.
Go ahead, Amy. I'm sorry. I was going to ask you a question.
No. Yeah, please. No,
So
go ahead.
You mentioned earlier that some of your counseling and some of the teaching you've done is on Fair Labor Standards Act and Family Medical Leave Act, which are two really integral components of the Families First Coronavirus Response Act, because if employers don't pay out, let's say, the paid sick leave that they're supposed to, then employees could theoretically come together and assert some kind of collective action against them under the Fair Labor Standards Act to get that money. And obviously, if you don't provide the expanded or emergency FMLA to someone who needs that time off to care for a child who is either home from school because the school is closed or doesn't have any other childcare options, then the recourse that an employee has if the employer screws that up is a claim under the Family Medical Leave Act. Have you been getting calls or hearing buzz? I know we're just getting started. We're like 2 weeks in, but
Right.
Have you been hearing any rumblings about issues, under those two laws, either specific to the FFCRA or otherwise?
I think it's important to keep in mind that the calls that we're getting are from employers who want to do the right thing, right? So they're reaching out to us, to say, how does this work? How can we best implement it? Because I think that, rightfully so, they're fearful that they might end up in that situation and they want to avoid that at all costs. So for us, it's not so much, we're not dealing with employees, we're dealing mostly with HR professionals, small business owners, you know, controllers in many cases. So really our guidance is more in providing them with that information so that they can make a good decision so that they don't end up in that situation.
Okay. I saw just this morning in Law 360, there was a lawsuit filed locally in New Jersey. I think it was in state court, although it could have been federal, or it'll end up in federal court because it was a Fair Labor Standards Act claim. But the headline, or the first few paragraphs, were: a New Jersey hairstylist has hit an out-of-state hair salon and its parent company with a collective action alleging that it stiffed workers' pay in violation of the FLSA after it shut down operations due to COVID-19 in the middle of a pay cycle. So not an FFCRA type claim, but certainly, the FLSA doesn't have any exception that I'm aware of, and the local wage and hour law and the wage collection law doesn't have any exception that I'm aware of to employers that are unable to make payroll. And that's a big thing here. If employees work and they record their hours, and the employer knows about the hours worked, especially if you're not exempt, then you're supposed to get paid for that time in your next paycheck. And when you don't, that presents a problem.
Right. So I actually did have a call this morning from a member, small company, 30 employees, and not able to meet payroll tomorrow for work performed last week. So her questions to me were, could we be in trouble for this? And, unfortunately the answer is yes, especially in New Jersey, it's, yes, you have the FLSA, but New Jersey has a pretty robust wage and hour law itself. And we now have the New Jersey wage theft law. So, which has incredible penalties on employers. So, this was only the first one that I've heard of this happening. But again, how many employers are not reaching out to us with these types of questions? This just happened to be someone who's trying to do the right thing, realize for, maybe not fiscally running their organization in, the utmost of ways, but, they were kind of panicking about what to do. Now they think they'll have the money next week, and they had their whole story of the client didn't pay, and whatever the situation was. But I it's a little scary. It's a little scary, and I think we will start to see more of that.
All right. Well, I'm gonna do a toss over and talk a little bit about what's going on in Pennsylvania. Okay. And I'll do this in reverse chronological order to try to bring folks up to speed. So let's take it back a few weeks to March 19th, which feels like a few years. But so that was when Governor Wolf implemented a deadline for all non-life sustaining businesses in Pennsylvania to close their physical locations by 8 p.m. to slow the spread of coronavirus. And the enforcement actions against businesses that don't close their physical locations have been in effect since then. And back at that time, Governor Wolf announced the availability of some low interest loans for small businesses and eligible nonprofits in all 67 counties in Pennsylvania through the U.S. Small Business Administration. And I think those are still available. This was before the CARES Act came into place, and most people are now focused on the Paycheck Protection Program to try and get your money. Although, I'm hearing that I just had a call with my colleagues, and like 1% of applicants are starting to get their money. So I mean, it's going to be a slow crawl. Since then, we know that there's still the stay-at-home order is in effect in Pennsylvania. The state has confirmed that a couple things with respect to unemployment compensation. We know that work search and work registration requirements for applicants or claimants for unemployment compensation are suspended. We know that the waiting week for someone who's applying for unemployment compensation in Pennsylvania is suspended. We've also gotten guidance, though, that where possible, employees who have access to paid sick leave, whether through their employer or whether through Families First Coronavirus Response Act, should take that leave before applying for unemployment compensation. I mean, generally speaking, before all this began, if you had some holiday pay coming to you, or if you had some vacation pay coming to you, that could be used as an offset. But now, amidst COVID-19, and I don't want to get into the nitty gritty, I'm going to do that tomorrow on the Facebook Live chat. But basically, just because you're subject to a stay-at-home order doesn't necessarily mean that you're going to have access to paid sick leave. If you're on furlough, for example, you're not going to have access to paid sick leave through the Families First Coronavirus Response Act. If you have your hours reduced, you're probably not going to have access to that. So in those situations where you don't have the ability to collect company provided paid sick leave or Families First Coronavirus Response Act paid sick leave or the expanded FMLA, then the employees can go and collect unemployment compensation. You can never get them concurrently. Employees with reduced hours can apply for unemployment compensation, just like in New Jersey. But employees that can telework, not only can you not collect the Families First Coronavirus Response Act paid sick leave, not only can you not collect the Families First Coronavirus Response Act, I'll just call it FFCRA or Families First. I'm gonna get tired if I keep saying everything. And sorry, I'm leaning over. Siri thought I said something, so it's dictating everything I just said. If you can telework, not only can you not get those FFCRA benefits, but you can't get unemployment compensation either, unless that you're not actually teleworking, you're using that time at home to care for children. So if you're using FFCRA leave for that reason number 5, which I'm sorry, folks, I know this law chapter and verse. I just put everything by numbers now. So number 5 being if you are unable to work or telework because you are caring for a child under the age of 18 or someone for whom you care in loco parentis, whose school is closed or daycare is closed or unavailable due to coronavirus, you can collect paid sick leave. You can collect the expanded FMLA, but you wouldn't be able. If you're collecting those, you can't get the unemployment compensation. If that's not available to you, then you can get the unemployment compensation. So if you work for a larger company, for example, it wouldn't be covered under Families First. And Pennsylvania wanted to make clear that employees should not and cannot pre-apply for unemployment compensation if they experience a layoff or furlough in a few weeks. So if you know that you're going to be laid off 3 weeks from now, you can't apply now and collect the money. I think I mentioned, or if I didn't, that for employers, a question I've been getting is how is this going to impact our unemployment compensation tax rate? And it's not. It's not going to increase due to COVID-19 unemployment compensation claims. By now, if you haven't applied, if you run a business in Pennsylvania and you weren't on the essential business list, you missed the deadline to apply for a waiver. That was Friday. I don't know if Governor Wolf is going to open that up again, but I haven't heard any indication that they would. So if you are a non-essential business and you're closed, then closed, although I think that list is getting updated from time to time. And the latest news, unless something just happened in the last, 30 minutes, earlier today, Governor Wolf confirmed that all schools will remain closed through the remainder of the 2019-2020 academic year. Amy, I can only assume it's just a matter of time before Governor Murphy follows suit. I mean, he's extended the stay-at-home order through May, or at least through 30 days from yesterday.
Right.
Schools around here end in June. I'd be shocked if my kids are going back to school. What do you think?
I'm in agreement. The Murphy yesterday said indefinitely, and waiting to see. So again, same thing. If we're closed through most of May, are they going to really have them go back for a few weeks in June? I don't know. I don't know, but I suspect we'll go that same route. But it hasn't been formally announced in New Jersey yet. Right now, it just says indefinitely.
Yeah. And let me share my screen really quickly and show folks. Hopefully you guys can see this. Let's see. I don't know. Here we go. Oh, whoops. I didn't share yet. So here is, and I'll scroll through this really slowly. Not that you have to read everything. I should have been doing this while I was talking about Pennsylvania. But here is, this is available from pa.gov. You have to dig a little bit into the COVID-19 section. But basically, here is a very easy to follow infographic that can help employers identify, based on certain scenarios, is my employee entitled to paid leave through the employer, paid leave under FFCRA? Can they get expanded unemployment compensation, and can they get workers' comp? So again, this is all available on pa.gov, and New Jersey is wonderful about preparing similar infographics. They have great resources for employees and employers, not just little charts that look like that, but 4 and 5 page, pretty easy to read documents. And Amy's been wonderful. If you're not connected with Amy on LinkedIn, you should get connected with Amy. She's been doing a wonderful job at posting these and keeping her LinkedIn connections constantly updated with updated guidance from the state of New Jersey. We've got a few questions that have come in, Amy. You want to see if we can answer these things?
Sure.
If you have questions, just you can post them to the group in using the chat feature. If you want to just send them to me, I'll be happy to moderate. So I can do that. But I'm just going to pick a couple questions at random, and let's see if we can answer these. This first question: does an employee ill with COVID-19 get New Jersey temporary disability benefits and FFCRA paid sick leave, even if combined payments exceed a normal day's salary?
No. So if the employee was diagnosed with COVID-19, first the organization would pay out, provided they were a covered organization, fewer than 500 employees. They would first pay out the FFCRA 2 weeks of pay, and that's full pay capped at $511 a day. After that, the employee in New Jersey would have the option of using any paid time off that they have available, whether that be their New Jersey earned sick leave or some other PTO, vacation, PTO from the PTO bank. And that would be at full pay. And then the employee essentially has a choice of where they go next. They could now, traditionally we would think of them as going to TDB next for the period of their disability. But with the CARES changes to unemployment is now available to someone who has been diagnosed with this. So a lot of the questions that we're getting from our members are, well, where should we direct them, to disability or to unemployment? I would say direct them to the Department of Labor's website. It's really going to be the employee's choice which one they apply for. Obviously, they need to be eligible, but they'll get to choose. The unemployment is attractive because it's going to pay more, and they're going to get that extra $600. But they could not collect simultaneous. So if the company is paying them anything, they will not qualify for temporary disability benefits or family leave insurance. With unemployment, it goes to a partial, they could be eligible for a partial benefit, but likely not if they are diagnosed. So not in that scenario. And
even the employee actually, if they wanted to, Amy, right, they could, under the Families First, they could decide to run their employer provided PTO first. The company can't insist upon it, but the employee could say, look, I want to be paid through my employer provided PTO. Now, I'm not sure why you would do that. Maybe if you're a higher earner because you're capped under the paid sick leave under federal at $511 a day. So if you're making, if you're making well into the six figures, you'd probably rather get your regular PTO. But other than that, the employee can decide to go first. And also the employer and employee can agree to do a top off, so to speak. So if you're getting paid at, again, if you're one of those higher earners and you're getting paid capped at $511 a day, you can agree with your employer during those first 2 weeks to basically get topped off and take some money out of your employer provided paid time off bank. I hope that was clear to everyone. I'm probably clear as mud, but this is complicated. And that's why, and we'll say this again, no legal advice here. This is all quite hypothetical. If you have questions when this is done, please contact your employment lawyer, whomever that may be, and ask those questions and get some specific legal advice. Let's see, other questions. Here's another question. In New Jersey, for someone with COVID-19 after 2 weeks of emergency leave, are they eligible for additional pay under the FFCRA?
So it would depend on it would depend on their scenario. I think the only additional pay would be if they were also covered under the emergency FMLA expansion, because that would allow them to be protected for a full 12-week period, 10 weeks of which would be paid, although at a lower rate. So it's 2/3 of their regular rate, and that's capped off at $200 a day. But that would be the only other money, I believe, that would be available under the FFCRA. And again, that's a pretty narrow, that's not if someone is sick. That's not if they're caring for someone.
Right. The underlying assumption here with it, someone themselves have COVID-19. So the only overlapping expanded FMLA, paid sick leave, reason number 5, which is if you're caring for a child who is home from school or has no child care. So if you yourself are sick with COVID-19 and you use up your first 80 hours or your only 80 hours of paid sick leave, then you're tapped out, at least as far as the FFCRA goes. And it's a scary thought. And the reason some people might choose to substitute their own company provided PTO first is, hopefully within the next month to whatever the curve is flattening, coronavirus hopefully goes away. But is it going to go away forever? And when we get into the colder months, October, November, December, does it come back? Are people going to want to bank some of that government leave, that paid leave for later in the year? I don't know. I don't know that people are as, that's a really grim view of society. But for people who are planning like that and they're thinking, look, it's use it or lose it, maybe they bank some away. I don't know. But I've seen that come up. Here's another question. Would you discuss for healthcare employers that are excluded under the new law how to handle PA and ANN employees? I'm not sure what ANN employees that refuse recall due to fear of or children being out of school. Okay, so I'm going to change this question around a little bit. And I'm going to talk about 2 things. One, the healthcare provider exception, because that actually came up with a client of mine today. And I want to talk generally about what to do with employees that are afraid to come to work. Let's say you have an essential business. So the healthcare provider exception is hecka broad. It is basically any employee that works for any type of medical business, whether it's a doctor's office, a nursing home, a visiting nurse association, a dentist. I was on a podcast the other day. I didn't know the answer to this one. Is a veterinarian covered? It's medical, but it's animals. That I don't know. but basically anything to do with medicine, or if you contract and support businesses that basically provide medical assistance, your employer has the ability, can but does not have to, exclude you from getting the paid sick leave or the expanded FMLA, not classic FMLA. I mean, if you're 50 or more employees, there's no exclusion there. But if you're under 500 employees and you're covered under FFCRA, you're not necessarily going to get that leave. And that's anyone. That's the person who performs the surgery. That's the person who helps out with the surgery. That's the person who in IT who keeps the computers on to assist with the surgery, and that's the person at the front desk who admits the person for surgery. You're all covered. You're all healthcare providers as far as this act is concerned. So what happens, whether in a healthcare situation or with any essential business, if you have employees who aren't telework, who are actually working, let's say it's a super.
I'm here working, but I'm trying to turn off this video because it's irritating me. I'm trying to calculate something that's driving me nuts. I think I may have stopped it. Good.
All right. Sorry,
Yeah.
muting you. Sorry about that. If you want, folks, if you want to turn off your video, there should be a little icon at the bottom of your page. You can just kind of click on, turn the video off. But don't turn your video on and don't turn your sound on, please. Thank you. So for folks that don't want to come back to work because they're nervous and scared, could you technically fire someone, or could you fire someone for that? Yeah, technically you could. I think in New Jersey, you may run up against a potential problem and a potential lawsuit down the line under the Conscientious Employee Protection Act. If an employee speaks out about working conditions or specifically public health and public safety in the workplace, and you fire someone after they complain, I think you might have teed yourself up to defend a SEPA claim. Pennsylvania, not as much of an issue in the private sector. In the public sector, there is a public whistleblower law that could be used. But I think the safer move is to tell someone, like, look, you don't have to come to work. You can stay at home. If you have PTO, use your PTO. If you don't have paid leave available to you, because you can't take FFCRA leave at this point. If you don't have any employer-provided paid leave, we can put you on an unpaid leave of absence. And when you're feeling better about it, we'd love to have you back, assuming we still have a spot for you. So I think that's the better approach, because a lot of people are scared to come to work, and forcing someone to come in isn't necessarily going to alleviate the problem. What do you think, Amy, about in the situation in which someone's afraid to come to work?
I agree. And that is not going to be a reason that they'll be able to collect unemployment either, even under the expanded reasons. Being fearful, there's a job there for them. So, that's important to keep in mind. Unemployment is available for so many more reasons, but being fearful is not one of them. So I agree with your analysis that after they use any accrued paid time, they would be out on an unpaid leave.
Yeah. I mean, you may, in that situation, be able to kind of work with your employer to negotiate some sort of a layoff or furlough, in which case maybe you can go and get your unemployment, but don't count on it. But I suppose, again, talk to your employment lawyer about that. I mean, I suppose that's potentially an option, although it's ultimately going to be up to the state of New Jersey whether someone is eligible for unemployment or not. So if you get into that situation with an employee, don't make any sort of representation. But yeah, you're definitely going to be able to get unemployment compensation if we furlough you. Here's another question. If an employee is asking for intermittent expanded FMLA and EPSL, paid sick leave, and doesn't provide an end date, do we leave it open-ended or use 123120? Oh, pretty good question. The statute doesn't address that specifically. In fact, the statute is just silent about intermittent leave. But the Secretary of Labor has said that the employer and employee can agree on intermittent leave, and they should agree on an intermittent leave schedule. So it's the employer that really holds all the cards here. And I would certainly recommend, again, in a not legal advice giving way, but just in a nice, consider the circumstances kind of way, that if an employee needs intermittent expanded Family Medical Leave Act leave, that you should work with them and provide it. I would work with them to figure out kind of how long they're going to need it for. I mean, logically, you're not going to need it for longer than, if you have a kid in school, you're not going to need it for longer than June, mid. If you have a kid in childcare, that's a different story. And work out an interval. Is it going to be a half hour? Is it going to be an hour? What's the intermittent leave period? That's something you're going to need to work out. And whatever you decide to do, document it. I've been preparing leave forms for clients. I've been preparing leave policies for clients. But really, you don't necessarily need a leave form. I don't think a physical signature is absolutely necessary. Maybe it is. The guidance is a little unclear. I think an email would suffice that documents what the leave arrangement is going to be and why the employee is taking the leave, because ultimately you need this for when the IRS comes and does an audit when you're claiming those tax credits. That's really why you need it, and frankly, no other compelling reason. Next question. If someone is eligible for partial unemployment compensation or a partial unemployment compensation claim, would they receive the full $600 of federal funds or a prorated amount under the CARES Act? Amy, do you know that one?
In New Jersey, yes. Basically, you just have to be eligible for unemployment. If you're eligible for $1 of unemployment, you'll get the additional $600. So that would impact anyone who's collecting a partial benefit as well.
I think the same is true in Pennsylvania. I haven't heard otherwise. And that's something that Amy was addressing earlier. I mean, it's going to be difficult for certain essential businesses like supermarkets or gas stations where your employees are getting paid, at or just above minimum wage. I read the other day, Kroger is upping it's $2 an hour for most of its employees. I mean, it's tough to be competitive with what you can get through unemployment compensation. If you're making, if you were making annualizing at $30,000 or so a year through your employer, you're going to get $50-something thousand through unemployment compensation between state and federal. So, I wouldn't blame someone for going to get the unemployment compensation.
So I do have one member that I have spoke with who needs employees coming into work. Their kind of solution, we'll see if it's a solution, but their way of approaching it is that they're now paying overtime for all hours worked over 30, right? Mm-hmm. So that's an attractive incentive, and I guess they're able to sustain that for a period of time. So, we'll see how that goes and if that can help people from, heading over to the unemployment system.
Yeah. Here's another question that's come in. From one of my favorites. Now that PA has closed schools through the end of this school year, how will we determine the end of the allowable leave timeline of caring for children when the 12 weeks has passed the original end date of the school year? Oh, I see. So if someone has requested expanded FMLA that would go into, let's say they take it starting now. 12 weeks would take us past June. It would take us into July. What is the end date? If it's for someone who has children in school, I would ask them to recertify, so to speak. When I'm doing my forms, I put somewhere in there that says if your circumstances have changed, you've got to let us know right away. So that's a conversation I'd be having with my employees who are taking this leave, because they ultimately have to certify that they are caring for children while school is closed due to coronavirus. Again, different story if it's childcare. And we'll see. I would expect some additional guidance from the Department of Labor on this issue, because I bet other people have this same question too. And I could see the Department of Labor saying, look, well, if the kid's not going to camp or other summer activity and the parent is responsible for caring for them, why is that any different than when the school is closed? But I'd say for now, use the end of the school year as the cutoff. I think you're pretty safe doing that. Although now I'll go back on myself and say maybe the safest thing, if you have the liquidity, is to just pay for the leave and get your tax credit.
Also, I think camp is a great point, especially for younger elementary school kids. So just because the school year is over, that parents need to care for the child whose camp is still closed because of that. They're not starting in June or July as they had anticipated. I think that would qualify as a place of care, the way, it's a pretty broad definition of who is a child care provider and what would qualify. But to your point, I like the idea of making sure that employees communicate that change in circumstance. So at least you have a sense of what's happening there.
Another one of my favorite people asking this question: if an essential business tells employees who could work not to, so essential business, employees can come in and work, but the business says don't, just to be safe, i.e. they are not prevented from working by a quarantine order, are they eligible for FFCRA paid leave? I'm going to say no, because I think that's akin to a furlough. It's akin to reduced hours. I would liken that to, we don't have the work available for you. We're open, we're essential, but we don't want you coming in to be safe. Although I have to question what's going on with that business. Like if you're open and you're essential, I don't think you're saying to your workers like, don't come in just to be safe. But I think in that situation, you're technically not subject to the quarantine order, because one of the exceptions is providing services to an essential business, but the essential business is basically saying we don't have the work for you because we're telling you to stay home. It's a bit circular. I don't know.
Yeah, it doesn't, to me on its face, it just doesn't seem to meet criteria 1 through 6 to be eligible, right? It doesn't fit squarely. So I would agree with that. And I think if it was looked, it could be more of a furlough situation, in which case unemployment would be the way to go.
Could be. Yeah, that's another good point. Oh, and by the way, for anyone who has questions about criteria number 6, just FYI, what I have done, I have flat out taken that out of my FFCRA policies. I've taken it out of my leave request forms, because if you're confused, employees are going to be confused, and I've just taken it out. And if and when the Secretary of Health and Human Services coordinates with the Secretary of the Treasury and the Department of Labor to come up with another reason why people should get FFCRA leave, I'll hand it back. Next question. Have you heard of employers of healthcare providers cherry-picking reasons for exempting them from EPSL, such as exempting these employees if the provider is sick or subject to quarantine for their own condition? Okay, so I think what's being asked here is, we have this broad potential exemption for healthcare providers, but can the healthcare provider, can the employer of healthcare providers then kind of slice and dice that and say, look, we'll provide the PSL under in certain scenarios, fact patterns, but not in others, because we're allowed to take advantage of the exemption. Have you been getting any calls about that, Amy, about slicing and dicing?
I have not. So so that would be, we're going to allow certain employees to take advantage of it and not allow other employees?
Yes. Yes. You've said it much more articulately and succinctly.
I think that might be okay under the FFCRA, but maybe there's other things you need to be worried about there, like how you're picking who is allowed to take advantage of it and who's not. And, are you backing yourself into a corner, like from a discrimination standpoint? I think there's other concerns there.
I agree. Let's see. I have one more question here, and then I guess we'll close out. Unless people have more questions, type them in. Would a Pennsylvania employer, I guess this will be me, would a Pennsylvania employer who has a large number of workers now working remote from homes in New Jersey be required to, no, actually this is going to be you, Amy. Would a Pennsylvania employer who has a large number of workers now working remote from homes in New Jersey be required to comply with the NJESL?
That's a good question. I might have to look into that. When New Jersey Department of Labor issued their final regulations on the New Jersey earned sick leave, they did indicate that they didn't give us a line in the sand as to how much time an employee has to be spending working in New Jersey. And they're going to be following up with a regulation on that. So they gave us some broad guidance. I could look that up and follow up. I don't recall off the top of my head.
Okay. Question just came in. Most important question: whose number is on my jersey? It is. Let's see if we can do it. It is. Andre Waters is on my jersey. Andre Waters, number 20. The original number 20 before Brian Dawkins. Andre Waters. Here we go. Next question. Could it be considered insurance fraud if an essential business that is operating asks employees if they would like to be laid off? In essence, the company is not being truthful to unemployment compensation because there is no economic layoff. I think it depends. I think it depends on the situation, right? I mean, if you're telling employees, like, look, if you don't feel comfortable coming in, right, then we'll lay you off and we'll find other people who do feel comfortable coming in. Is that fraudulent? I don't think that's fraudulent. I mean, I think it's just looking out for the welfare of your employees. The company doesn't really get anything out of it. It's more for the benefit of the employees. So I guess I don't know that it's insurance fraud. I mean, I guess I'd be okay with it, but I think in reality, that's going to be tough to pull off. Amy, do you want to touch that one?
No.
Okay. Okay. Well, folks, actually, you know what? Let me see if I can do this really quickly. I know there were a couple of pre questions that came in that we have about 5 minutes left that we can answer. Sorry, my webcam is in the bottom of my laptop screen, and I have a couple of screens up. So if I'm looking up, it's not as if I'm trying to ignore people. I just have to read the my larger monitor. Here are a couple of the additional questions that came in. When we process pay for employees electing either paid sick time or expanded FMLA for childcare, are those earnings 401k eligible? Oh boy.
Yes. And that's according to IRS guidance that they published on the FFCRA. Qualified leave wages are considered wages for purposes of other benefits that an employer provides, including 401k.
Awesome.
And those wages, if I recall, they're also going to be subject to income tax withholding and the employee's share of Social Security and Medicare. That's one of the IRS's FAQs.
Okay. Here's another question. This is a bit involved, and I prepared for this, so I have an answer. Question. I've read conflicting information about the regular rate of pay with regard to FFCRA. I thought it was the average rate of pay over the last 6-month period for all employees. If they have not worked for 6 months, it's their current rate of pay. We have an entire state who received increases January 1st. Our payroll system is calculating it over the last 6 months, so they are not receiving their current rate of pay. What should it be? Average over last 6 months or current rate of pay? And here's the answer. Hold on, I wrote this out. So for purposes of this FFCRA, the regular rate of pay used to calculate your paid leave is the average of your regular rate over a period of up to 6 months prior to the date on which you take leave. So if you have not worked for your current employer for 6 months, the regular rate used to calculate your paid leave is the average of your regular rate of pay for each week you have worked for your current employer. If you are paid with commissions, tips, or piece rates, these amounts will be incorporated into that calculation to the same extent as they would be in the calculation of your regular rate under the FLSA. You can also compute this amount for each employee by adding all compensation that is part of the regular rate over the above period. Divide that sum by all hours actually worked in the same period. If you separately, and I'm not going to get into it now because we're running short on time and I want to close by the top of the hour. There are separate ways to figure out full-time versus part-time, and I don't want to blow anyone's mind right now. Let's see. I think we have time for one more question, and then we'll let it go. Here's a good question. I have a question about reasonable accommodations for those who are currently teleworking due to the pandemic. And this person in their question notes, this is distinct from providing telework as a reasonable accommodation. So we're talking about folks who have no disability. What does the EEOC have to say about the obligations of employers to provide employees with equipment, furniture, ergonomic workstations, et cetera, for home offices? The answer is you don't. For folks that don't have a disability, you don't have any duty under any federal anti-discrimination law to accommodate them, with the exception of pregnancy discrimination. So if under the Pregnancy Discrimination Act, you would have an obligation to accommodate someone who is pregnant in the same manner as you accommodate non-pregnant employees who are similar in their inability to work. That's what the Supreme Court said. For someone with a disability, it's just a regular kind of an ADA interactive dialogue conversation. If the person doesn't have a disability, you don't have any duty to accommodate them. But as I've stressed before, do not resort to stereotypes, right? So I talked about this yesterday on the blog in the context of an age discrimination case. When this whole COVID-19 thing starts to wind down, don't, let's say, delay older people coming back to the workplace because you think that, they're going to be immunocompromised and we want to look out for their well-being and best interests. So you have the younger people come back first and they're earning that paycheck before the older people come back. So don't do that. Don't resort to stereotyping. Just follow the law. So I want to thank everyone for their time. We have recorded this, or I have recorded this. Hopefully I clicked the record button. I'm going to upload this to YouTube. I want to thank Amy Vazquez for her time. Shout out to Amy. Shout out to the Employers Association of New Jersey. Again, if you haven't, if you're not familiar with Amy and you're meeting her for the first time today, search for her on LinkedIn. She has so many wonderful updates. And I think the Employers Association of New Jersey is obviously doing a great service and right now and at all times for local businesses. As for me, you can connect with me on LinkedIn too if you'd like. You can also find me at my blog, theemployerhandbook.com. Also, you can check out my bio and learn more about me at fisherbroyles.com. That's FISHERBROYLES.com. Amy, thank you so much for your time. I appreciate it.
Thank you, Eric. It was great. It was a great session.
All
enjoyed
right.
it.
Bye, everyone.
Take care.